Hello everyone, I welcome you to the session. All my sessions are for educational and academic purposes only. I do not allow members to record the session and I do not provide any legal advice during the sessions. Today we are going to discuss knowledge of which is kind of one of the mens rea mentioned in the syllabus. So we have already discussed different types of mens rea. We have already discussed different types of questions as well. So today we will discuss knowledge, willful blindness, and recklessness, and objective mens rea. So four different types or four different shades of mens rea. Knowledge, and then those three rules which we discussed earlier, like in our last session, they will be applicable on all the offenses. So your NCA syllabus says the accused must generally know that the condition of the actus rea exists. For example, the accused cannot be convicted of assaulting a police officer if they do not know the victim is a police officer. Generally, it is reasonable to assume that the accused knows the things that would be obvious to a reasonable person, and so we tend to conclude that the accused knows the relevant condition. Okay, let me simplify the concept. Knowledge you will discuss in your answer if the section says knowingly. Knowingly. When you read the offense in the criminal code, and if the section says knowingly, then this is a hint for you that you have to discuss knowledge as the mens rea. As we discussed in the last session, that we may have to discuss two different states of mind. We agreed that we will, instead of calling them mens rea, if we call them states of mind, then it would be easy as per guidelines of the NCA syllabus. NCA syllabus guides you. There are many states of mind. There are many states of mind. We have also discussed that you may have to discuss two different states of mind. Which two states of mind? That we do not know. That we do not know. Um, which two states of mind, huh? So but whatever we get, though this is mentioned here, huh? So 6A, 6B, 6D, 6E, these are different states of the mind. So wherever the word knowingly is mentioned or knowledge is mentioned, then you will be discussing 6C of the syllabus. But is that the only mental states? Answer is no. You may have to discuss other state of the mind as well. So let's go and discuss the brief summaries of the cases so that we can understand how courts interpret the word knowledge. How courts interpret the word knowledge. So we are going to read from the brief summaries of cases. All these cases have already been given to you. I am just updating them again a little bit, but 90% they are the same, but I may make some changes in that, but 90% it is the same. Please do not worry. There is no big change in that. We are going to discuss now cases for the knowledge. So knowledge cases starts from chase case. So we have three syllabus cases, I think. For every topic, we will discuss. So if you look at this, it says even to case 199 Supreme Court. Then there is Barton case 2019 Supreme Court case. Then ADH is 2013 case. Huh? So we will discuss two syllabus cases for this purpose. Also, I think two or three of you also has the book. If you look at that, NCA suggests that you may like to read from page 505 to page 515. These are 10 pages for only knowledge, and then 3 pages from this. So around 13, 14 pages NCA is expecting from you that you should read, and also those cases. So let's read the case of Ivanchuk, which is a Supreme Court case for understanding the concept of knowledge. And as I said, what is required that if in not knowingly word has been used in the section, that is a hint to you that you have to discuss knowledge. R versus Chase. The appellant, Chase, was charged with sexual assault after he forcibly raped the complainant, a woman he had been dating. So the person has been charged for sexually assaulting a woman. The complainant, who is a female, the complainant, who is a female, testified that Chase had been harassing her. Okay, Abda is raising hand. Yes.
Sir, the knowledge cases start from R versus Ivanchuk. Case is from the last
Oh,
chapter.
Ivanchuk. Okay, okay. Oh, yes, yes. I also.
Yes,
But
sir.
where is Ivanchuk? I think
After
that
that,
was.
after
Huh?
cheese. After cheese, yes.
Okay, okay, right, right, right. Oh, you are right. Okay. I was also thinking that why the facts are a little bit different. Okay. Thank you. So let's start from Ivanchuk. So this is the case for knowledge. The accused interviewed the 17-year-old complainant for a job in his van and then led her to a trailer where she felt trapped. He made progressively more intimate sexual advances despite her repeatedly saying no. So now you have to see if this person has the knowledge, right? Mira, Nimoni, you have to understand it from this perspective. Whether the person who is sexually assaulting this 17 years girl, whether he has the knowledge or he does not have the knowledge. If the crown prosecutor proves then he has the knowledge, then it means that he has the. If the complainant proves that I do not have the knowledge, then it would be assumed that he does not have the mens rea. This is how we need to understand the cases from the perspective. He made progressively more intimate sexual advances despite her repeatedly saying no. So the girl is saying no, no, no. It means the girl is not giving consent. Please remember we discussed the topic express consent or implied consent. In sexual relationship, express consent is required, implied consent is not helpful. Although he momentarily stopped each time, he resumed shortly after with more serious advances. The complainant complied out of fear. Out of fear. Now the girl has agreed to have some kind of sexual relationship with that person, but that was out of fear. Now, can that person say, I have the consent of that? Do you remember we discussed a section where it said that if someone is giving the consent because of fear, because of authority, then that means that that consent is not
Right.
valid. So this girl is giving the consent because of the fear. So that means that vitiates the consents, which the accused was aware of. The trial judge acquitted him. You can also see how different courts interpret the situation. So you I am very clear, and most of you will be clear that whether the girl is giving consent in this situation, answer is no. The girl is saying no. But then the trial judge still acquitted him. It means the trial judge is saying that this person does not have the mens rea based on implied consent. See here, even you can say that this girl does not give the consent. Just to check your understanding whether you are following or not. Mira, which line says that there is no consent? Gift, which line says there is no consent? Gift? Anyone, quickly, quickly.
Saying no.
Hmm?
When she says no.
When she said
Yes, when she said no, so it means she's not giving consent, but you can still see that the trial judge acquitted him. The trial judge is thinking that this is okay, but even you can say that there was no consent. And the Court of Appeal upheld the acquittal. It means even Court of Appeal is saying that this girl gave the consent to that employer. Now, the matter went before the Supreme Court. Whether the trial judge erred in his understanding, erred means made a mistake, erred in his understanding of consent in sexual assault, and whether the defense of implied consent exists in Canadian criminal law. Supreme Court held. The Supreme Court ruled that consent is subjective and based on the complainant's state of mind. The defense of implied consent does not exist in Canadian law. So I have advised all of you that when you write the answer, you do not discuss facts of the case. You only discuss ratio of the case. For example, in your question, the question is whether this girl gave the consent, but the fact pattern suggests that it was not an express consent, it was an implied consent. Then how do you relate it with the syllabus case? You say in R versus Ivanchuk, the court said that there is no concept of implied consent in Canada. In this fact pattern question also, the lady, it looks like, is having implied consent, which is not the requirement is express consent. The accused perception of consent is irrelevant unless you raise a defense of honest but mistaken belief in consent. The trial judge erred in law, appeal was allowed, and overturning the acquittal. It means it was decided against Ivanchuk. So the previous court acquitted him, but the Supreme Court overturned the acquittal. So that is Ivanchuk. Let's read one more case. For every topic, let's read two cases, not all, because then it will take a lot of time. R versus ADH. Okay, Amrit, yes, please.
Sir, I want to know what is the age of consent in Canada?
I think 18. That
18?
is why if the victim is under 18, then they say that there is a double punishment.
Okay. So I mean, like so if your age is under 18, you can be so under 18, you cannot give your consent, basically.
You cannot
I
give
thought
yes.
it was 16. Isn't it 16?
I think I think 16. I think 16. I think when we were reading the text of the section.
16, sir.
Yes, I think 16. Yeah, that was 16, huh? 16. Yes, you are right. I think when we were reading the section 265, was that 265?
Yeah, sir, it was like 14 years for the under 16 and I think 10 years for like the normal.
Sorry, say it again, Abda.
Sir, it was like the 14 years imprisonment for the under 16.
Okay, no, but did we read somewhere what is the age requirement, or it was only the punishment which we read?
Only read the punishment, sir.
Sir, yes, in 271, the complainant is under the age of 16. That is what is mentioned for sexual assault.
Okay, so then can we say, Amri's question is, what is the age for giving the consent? Then can we say 16 plus?
So I think that doesn't, say the age of consent, right? It is just that the sexual assault, if it is done against someone who is under 16, then the offense is different. And for the
Then the
person who is
offense is
under
different, and
14,
then the accused gets more punishment.
yes, and if it is under 14, then the punishment is different. That is what is being mentioned, I guess. That I
Okay.
think doesn't give that consent should be.
Just opened
Okay.
the
All
Government
right.
of Canada.
But it's 16, I think.
It is 16. I just opened the
Yeah,
Justice
sorry.
Canada website.